So what do you make of the latest ruling in the Makate versus Vodacom battle? Is it a miscarriage of justice? Who's to blame for the almost 18 years of litigation? Send us your views via WhatsApp. The number, of course, is 0721105584, or give us a call on 010-594-6010. We've got our panel of experts giving us their views as well this evening. I'm joined by legal expert Mr. Benedict Phiri, the director of the Center for Intellectual Property Law at the University of Pretoria, Professor Steve Cornelius, and, of course, Stuff Magazine editor Toby Shapshak. Gentlemen, a good evening to you. Thank you so much for joining us. Benedict, I want to start with you because I think that there was a sense that when we got into or expected that we'd be seeing Makate versus Vodacom in the Concord this morning, there was a sense that, okay, perhaps now there's going to be some sort of, resolution to what has been an 18-year-old battle. And now, essentially, the court sending the issue right back to the SCA. For the sake of our viewers that were not lost in jargon here, why, in your view, is this taking place?
Yeah, so we must remember that, good evening, Naledi, and good evening to the viewers. This installment of this matter basically concerns Vodacom appealing against a High Court judgment which sent the determination by the CEO back to the CEO to determine that 47 million that he'd awarded to Mr. Makate within certain parameters, stricter parameters. So Vodacom wasn't happy with that result and took it to the Supreme Court of Appeal. But not only did the Supreme Court of Appeal basically not deal with that issue, it basically strayed into another terrain and granted an order that basically wasn't requested by any of the parties. And in doing so, as Vodacom argued in this particular matter, basically did not take into account a number of fundamental facts, a number of fundamental legal principles were mischaracterized. And literally, that was really the question that was in front of the Constitutional Court, whether the Supreme Court of Appeal had actually discharged of its duty to do justice before the parties, rather than the question of the quantum, which was, in fact, really before the CEO at that particular point in time. So that's really what the matter was about today. And I think a big judgment by the Constitutional Court, because really, it's the first time that a court is being called out for a failure of justice, as the Constitutional Court says it, to the extent that it actually violates constitutional rights of the litigants ahead in that court.
Yeah, interesting that we'd have this from, some of these words from Madlanga, who today was, of course, seeing, his last day as Justice of the Court. But Toby, I want to bring you in here. You've been writing about this issue of Makate versus Vodacom for a very long time. And I wonder if you expected that 18 years later we'd still be here, where the issue now is being sent back to the SCA. But the real question is going to be whether or not this can last any longer for Makate. I think that's the big question.
Sure. So I've been writing about this for years and years, and the central question I have is, if Mr. Makate invented Please Call Me, where is his patent? Because that's how this works in the world. If you invent something, you go to patent lawyers. Patent lawyers take it to the patent authority, which sees if anything else of this nature has been patented before or invented before, and they give you a patent. That's how it works. If you have a conversation with your boss 5 days after someone else at MTN briefed patent lawyers, and your boss, who's not empowered to do this, gives you a verbal agreement, That's not the same as inventing something. If you invent something, then you have a patent. And this is the thing I just keep asking over and over. Every time I ask Mr. Makate this question, he disassembles, he attacks my credibility, he refuses to respond, he blames Vodacom for not calling Ari Khan, who's the original inventor at MTN. He attacks me, he attacks Vodacom. He never answers my question. I spoke to him last year. I wrote what I thought was the definitive piece about this long-running saga. I mean, it is 18 years. And I went through all the data. I've got copies of Ari Khan's patent application. I've got copies of all the paperwork from all the litigation. And in fact, one of the pieces of information I cite that Mr. Makate himself cited during the original trial, the main trial in 2013, was he tweeted a picture of a patent application by MTN, and he wrote on it in with bright orange highlighter, Vodacom is a liar, and he stipulated this is why. And yet the patent that he wrote this on and that he included in his legal challenge and posted on Twitter in 2013 is the wrong patent. He cited the wrong patent. So, that's what I'm asking. I'm a journalist. I deal in facts. I don't deal in verbal agreements with your boss. I deal in what is before the courts, what was before the patent office, who patented the idea, who came up with the idea first, who was the lead data engineer at MTN who had the technical know-how to create this kind of system, who laid it out in very specific legal papers with Spoor and Fisher, MTN's copyright lawyer. 5 days after that, the industry assumes there would have been some leakage, is what people call it, or there would have been some rumors. A trainee accountant working at the rival firm comes up with this idea, takes it to his boss, tells his boss, who is not empowered to do so, offers him a percentage of income, even though labor law in South Africa says if you work for a company and you come up with an idea, the IP of whatever you come up with rests with the company you work for. The professor can confirm if this is not. And all along through this process, Ari Khan at MTN goes through the process, applies for a patent, is awarded a patent. MTN starts the service. 3 weeks after MTN starts the service, Vodacom starts their own Please Call Me copycat. And then because of extraordinary hubris in the then CEO of Vodacom, Alan Not Craig Sr., he claims in his autobiography, that he invented the idea himself, which is, of course, patently not true. And as a result, Vodacom never defends itself in court. It never says, we just plagiarized the idea. We copied MTN. It was the beginning of the telecoms war, the cellular wars. There were big egos involved. Alan Not Craig paid the price. He was humiliated in court when he was forced to admit that he didn't invent it and that it wasn't his idea. And because Vodacom never presented any evidence in court that they had lied, that they had plagiarized the idea, that Alan Not Craig Sr. took credit for it, because none of this was before the courts found that Mr. Makate had invented the idea. But what they really found was that Mr. Makate had a verbal agreement with his boss at Vodacom. History shows that the person who invented Please Call Me is Ari Khan, who briefed MTN's lawyers, et cetera, and that is the legal actual history of this patent.
Okay.
This Please Call Me saga before the courts is an entirely separate conversation.
And I need to highlight this, that given everything that Toby Shapshak has just said, that we do need to remember that this is, of course, not the first time that we've seen Makate on this matter before the Constitutional Court. It was in 2016 when the court did go ahead and affirm that Nkosana Makate is the inventor of the Please Call Me service. That's a 2016 Concord ruling. Prof. Cornelius, what do you make of what we've heard so far? I mean, it's shocking that 18 years on, this is where we are. We're still going, well, did he create the service? So what do you make of the IP debate here?
Well, I think, and I think Toby is 100% correct. It's actually not an IP debate that's going on here. The issue that came up was not about the intellectual property, about the creation of it. It is actually whether there is a contract between Vodacom and Mr. Makate on coming up at Vodacom, at least in terms of his claim, with this idea. And the courts have found up to the Constitutional Court that there is this contract that was tacitly agreed on. Now, going on pure contract law principles, there's a lot of questions one can ask about that finding as well. And I think the current saga is not surprising to me, because with all due respect to the Constitutional Court, in its 2016 judgment, it made a very grave error in handing down that judgment. Now, if parties are to negotiate an amount in terms of a contract or a performance, in this case, the payment of money, then there must be an independent deadlock breaking mechanism. And that was confirmed by the Constitutional Court in the case of Shoprite versus Everfresh. Now, in this case of Vodacom versus Makate, what does the Constitutional Court do there in 2016? They say, go back and negotiate the settlement. But if you can't agree, then the CEO of Vodacom decides. Now, the CEO of Vodacom is Vodacom. He is going to represent the interests of Vodacom. There should have been an independent indicator. The correct answer in that case would have perhaps been to say the auditors of Vodacom must then make an expert determination, because they are independent in terms of law. But the CEO of Vodacom is not an independent determinator. So in terms of the law of contract and in terms of their own other rulings on similar matters, the Constitutional Court, I think, sowed the seeds for this current dispute to continue, because the wrong person was assigned the obligation to actually make the determination.
Sure. And where does that leave us? What happens next? We're going to take calls. And then we also need to start talking about the monies that are being asked for here, right? 5% to 7.5% of the revenue collected as a result of this invention. Can he get there as Makate? Or will he land at 47 million rand? And then there's, of course, the question around what the past 18 years has cost him in legal fees. But let's take some calls. 0105946010. Mbuyisa is in Pietermaritzburg. Mbuyisa, good evening.
Hello, how are you?
I'm well, sir. Thank you so much for calling. Talk to us.
Yes, you know what? Firstly, I want to correct your second speaker there, Toby Shepshek.
Okay.
And it is rather unfortunate that he came to a TV watched by millions and millions and started to question Makate's patent with regard to the Vodacom, to the police call. What he is saying is no longer existing. It's neither here nor here. Because I'm saying this because Vodacom itself considered that Makate is the one who invented it. So that is why they are willing to compensate. So this thing of Toby Shepshek to come on TV to say that Makate was attacking him when he wanted this and that and that, for me, I'll be blatant. I think it is an issue of a jealousy when this thing is faced a black child. I mean, this is a brainchild of the black child, and he deserves it. And I want to say to Shepshek, if the inventor of police call was a white man, this matter could have been resolved long ago. So he cannot attack Makate. He must not be personal. He must state the facts. Vodacom confirmed and acceded that Makate is an inventor. So what he's saying surely is out.
Okay.
Thank you, Nali.
All right, thank you so much. And again, I raised this, that there was the affirmation from the Constitutional Court in 2016 as well. Mbuyisa, thank you so much for calling. We're going to continue with this discussion and take more WhatsApps and calls on the other side of this short break. Do stay with us. Welcome back. We continue to get reaction and expert opinions as well from the outcomes of the Concord sitting of Nkosana Makate versus Vodacom, an 18-year legal battle that has gotten the country enthralled and watching it so closely. Who invented the Please Call Me invention? 2016, the Concord says it is indeed Nkosana. But now, how much should he be paid is the ultimate question. Vodacom offering 47 million rand. Makate says he wants 10 billion. But we're taking your thoughts on this one. Send us a WhatsApp on 072 110 5584 or give us a call on 010 594 6010. After the Concord today sent the matter back to the Supreme Court of Appeal. Let's take a look at a few WhatsApps. Kabelo Ntwane in Limpopo says, hi everyone, I just wanted to send a special message to Mr. Please Call Me Sir. I want you to know that we're all rooting for you and you need to stay strong. Kabelo, thank you for sending in that WhatsApp. Bongani Mtembu says, as a country, we're facing a serious crisis where our justice system is in the hands of confused people. I feel sorry for Makate for the back and forth of over 2 decades. Not over 2 decades, but yeah, something like that, I suppose. Good evening. It's Velile Munyana from Rand West Gauteng. Makate's battle with Vodacom shows how our justice system delays fairness. The man created a service that helped millions of South Africans, yet he's been fighting for recognition for 20 years. Big companies should not drag ordinary people through endless courts to avoid paying what is due. I hope the SCA will finally deliver justice and send a clear message that innovation must be respected in South Africa. All right, Velile, thank you so much for that. We continue with our guests. And of course, we still have Benedict Phiri, our legal expert. You know, one of the big debates today has been, what does this cost Makate for the past 18 years? When we start to do the mathematics of what he ends up with, what is lost to the legal costs. If, for instance, he gets the 47, I'm going all the way down the line here, right? We end up where he has to accept the 47 million rand that comes from Vodacom, and you can talk to us about the route that we take to get there, what that would leave him with, if, you know, the costs of what all of this would have been on him. And 10 billion that he's asking for, do you see that as anyway plausible, feasible? Benedict?
Yeah, I think, you know, Naledi, the problem with that Supreme Court of Appeal order, which effectively puts the claim in the tens of billions, is because it was premised on a range of what would have been the percentage due to him from the revenue relating to that Please Call Me service. And, you know, a range is never suitable when it comes to a court order, because a court order has to fix very precisely the amount of money that a litigant owes another litigant. So we can already see that that 10 billion, you know, it's almost like a thumbsuck, effectively, from the Supreme Court of Appeal. And we don't know what then the potential real number could be for Mr. Makate, because, you know, one of the contributing factors is that the parties are coming from two very different perspectives. You know, the models that Vodacom presented in arriving at that determination, which sort of ranged between 30 million and somewhere around the 40 million, are very divergent from the models that Mr. Makate used in arriving at his billions. And the issue, as Prof. Cornelius has sort of indicated earlier, is that the issue was left for the determination of the Vodacom CEO as the ultimate arbiter if there was such a divergence between the parties as we've seen now. And ultimately, really what the courts have to decide is whether what the Vodacom CEO came up with is so horrendously wrong that the courts must then step in. And if they then step in, would they then be empowered to then come up with the right amount?
Yeah.
So I think it's going to be a long road.
So let me step in there, Benedict, because I want to ask you this. I want to stack a thought on top of that. There's the difficult determination that the court needs to make about whether or not Vodacom's offer is fair or not, which is, you know, that could go absolutely anywhere. But in that consideration, could the court then consider that it has been 18 years and 18 years worth of legal bills?
Yes. So if Mr. Makate is successful, you would have seen there was also quite a discussion around the Supreme Court of Appeal's computation of a term called mora interest, as well as interest that's calculated in terms of the prescribed rate of interest act. So, you know, when you win a money judgment or a money order, you know, the court does rectify for the period with which you've been in dispute by awarding that mora interest or that interest under the Prescribed Rate of Interest Act to account for the value of money. So, should he be successful, it's not going to be a case that his claim will not be vindicated. So even if at the 47 million, it will be 47 million plus all of the interest over the 18 years, which I don't know what that figure looks like today. So it should cover his legal fees. I mean, they are substantial after all these years, but when you add interest on that number, you should get a situation where his legal fees are sufficiently covered.
Yeah, Prof. Cornelius, I'm going to give this one to you. 49 million rand all the way up to 10 billion rand, or 5 to 7% of revenue collected. Where do you sit on that very wide scale?
Yeah, it's a difficult question, and I think that's where the Supreme Court of Appeal should have considered what the CEO determined. In terms of royalties for intellectual property, a fee of between 5 and 7.5% is not extraordinary. The question is just also, how do you calculate that 7.5 or 5%? Is it on the gross turnover? Is it on profit? And all of those kinds of models make a big difference on the amount that one comes up with.
Yeah.
And I think that's where the problem is at the moment, is that Vodacom has one model that they apply, which looks at the profitability of this project. And obviously, Mr. Makate looks at the bigger picture and has a different model. So, and that is really, and I think, as Benedict has said, the important thing that the Constitution or that the Supreme Court of Appeal should have decided is whether the CEO of Vodacom was really acting in a grossly unfair manner and in an inappropriate manner when he made that determination. And I think that's where they missed the point in their ruling. And it's I think a slight crisis, I think, for the Supreme Court of Appeal, that a unanimous judgment from the Constitutional Court tells them that there's a miscarriage of justice in that case. They will really need to take some deep introspection on how this case was handled in going forward, and make sure that they make a good ruling going forward now in this. But I foresee that whatever is decided there, it will end up in the Constitutional Court again.
Yeah. Toby, you've ruffled quite a few feathers with your earlier statements. And so, I mean, you see Mbuyisa saying that you know, this is the invention of a black child, that if this was a white man's invention, there wouldn't be such massive pushback. I wonder what you say to that, because it is such an emotive issue for South Africans. And then there's the question, well, if it wasn't his invention, why the concession from Vodacom? But I do think Prof. Cornelius did deal with that a little bit. But I want to hear your scale, right? 40-odd billion all the way up to 10 million, all the way up to 10 billion, like getting my M's and my B's wrong there. But where you go, yeah. Toby?
So I'm not here to give you legal opinions. I love you. I'm on the same side as you. Watch my TED talk. I'm all about giving credit where credit is due, and believe me, there isn't enough of that. But I've been writing about this for 18 years, so long that Newzroom Afrika still calls my publication a magazine, when we've been digital since COVID for 5 years at least. I've been writing so long. The media that I write for has morphed completely. The bottom line is this: it's like saying the Russians landed on the moon before the Americans, when we have the footage of 1969 of Neil Armstrong landing on the moon. As the professor said, with all due respect to the Constitutional Court, they have got it wrong. They made a judgment of fact based on the facts before them. And based on the facts before them, they have given the credit for inventing, please call me, to Mr. Makate. The real facts in the real world, where the rest of us spend most of our lives, except, Jacob Zuma and the like, we know that the way to prove you invented something is to file a patent. If you file a patent and the patent is awarded, then you can be said to be the inventor of something. Lots of other people said they came up with the light bulb, but as it happens, Thomas Edison patented it before everybody else. I mean, the guys from Philips in Eindhoven in Holland, in the Netherlands, got there at around the same time, but Thomas Edison made the patent and got the patent application in first, and therefore is accredited as the inventor of the light bulb, the reason you can see us.
But we find ourselves here now, Toby.
An agenda.
Yeah.
I just don't. But I can't help the fact of the matter being that the person who invented it put a patent application in. 5 days after that, someone else told their boss they had a good idea. And what we're seeing before the courts right now is a contract negotiation.
Okay,
it's not
Toby, I need to move the discussion along. And you've made that point, but this is what I want to get from you, because now we find ourselves here where we're going back and forth about how much it is that Nkosana Makate should be paid. What do you say to that?
I'm not a legal expert. Both of the legal experts have said, as have legal experts told me, if you're going to make a court determination, you can't make it across a range of from this percent to that percent. It has to be a very specific thing. I believe that's the law that's involved. The second determination is on what calculation of Vodacom's business do you make it? These are not questions, unfortunately, I can ask you. I'm just a journalist who's written about the lack of evidentiary proof for the patent.
Yeah. I must say, you're putting me in a position where I have to say that Jacob Zuma, of course, the former president, is not here to defend his own name. But let's take some calls. Molefe is in Kimberley. Molefe, good evening. Thank you so much for calling.
Good evening. How are you?
I'm well, Tate. Thank you for calling. Talk to us.
I'm not also in the legal department, but as I said, we've also been merchandising for Coca-Cola for a couple of years. Now I'm struggling. It's the very same case. It's a similar, very same case like this one. Children vending, it was my company. Multitech Africa, it was my company. I was shares of 51%. Mr. Makate, I think Vodacom is prolonging the case against Mr. Makate. They have to reach an agreement. And what I like about Judge Sanga, when he referred the case back to the FCA, she was right. She was absolutely right. Because the calculation, they appointed their own, the CEO on the finance department. Now she has resigned. It's another tactic that they are applying. So for me, the court is right when they talk about they must appoint independent accountant.
Yeah.
You understand?
Yeah.
The very same thing like Coca-Cola. Coca-Cola, let me just give you a light of
Briefly, Molefe.
Yeah.
Okay. All right, he's gone. All right, we're going to let you go then, Molefe. Thank you so much for calling. Interesting points, though, from Molefe in Kimberley. We're going to take a short break. We'll get final thoughts from our panel on the way forward for Makate, for Vodacom, on the other side of this. Stay with us. Welcome back. So Makate versus Vodacom still very much the talking point as we wrap up this discussion, and we take a look at a couple WhatsApps from our viewers. Let's bring those up on the screen. Jay says, if Mr. Makate is the real creator, please call me. Why in 18 years he hasn't discovered anything new? He can't be fighting for something for so long and does not have any fresh idea to date. Let him take what's provided and chill. Okay, Jay. Thank you so much for that. Anonymous says, Mr. Please call me. It's been over 18 years now. Please take that 47 and that 5%. Open your own tech company if you didn't already, and invent. I think that's invent. It wouldn't be invert something new. Then before taking it out there, trademark it and work. Okay. Anonymous, thanks for that. Tembile says, shame on the Concord for their failure to put this matter to bed today. Why should it be a tall order to give Nkosana what's due to him? Tembile, thank you so much for that. All right, let's get closing thoughts from our panel. Prof. Cornelius, in about a minute, if you can, game plan, if you were to sit in the room with Vodacom, and then, of course, with Makate, different game plans that you'd give to either side.
Yeah, as I said earlier, I suspect, obviously this now goes back to the Supreme Court of Appeal. It will be argued again, based on the papers that were before it previously. So they will now make a careful determination, and I'm certain after this it will be very careful. But I can foresee that whoever, I doubt if both sides will be happy with whatever is determined. So I can see that that determination will go to the Constitutional Court. The Constitutional Court today was correct in referring it back. That was the appropriate order to make, because effectively the Supreme Court of Appeal did not apply its mind properly. But I can see both parties gearing up to go back to the Constitutional Court at some time.
Yeah. Toby, game plans?
I'm only married to a lawyer. I don't think that people would ask my legal advice necessarily. I mean, in practical terms, I don't see how this is going to change much. I think we'll be having this conversation in a year from now, Naledi, and 2 years and 3 years, and that it'll go backwards and forwards. There's a lot at stake here, and it just seems like one of those problems that's not going to be resolved, because at the fundamental level, the Constitutional Court has made a finding on who invented something without there being an actual factual basis. In the real world, the facts of the matter are the patent application was filed by someone else. That's how we recognize the ownership of an idea. Who invented is the person who filed the patent application. Yeah. And there is no such thing for Mr. Makate. And as much as he continues to fight this fight, I can't imagine his legal fees are going to go down, and I can't imagine that the award is going to go up. So in pragmatic terms, this is probably as good as it gets, as the Jack Nicholson movie title goes. In pragmatic terms, what lawyer is advising him to carry on fighting something where his ultimate rewards are just going to be less and less and less? Yeah. I can't imagine what the cost of 3 counsels at the Constitutional Court can do. The 2 legal eagles on the call could probably tell you. I'm sure that's, a couple of million rand.
Yeah. Benedict, perhaps that's a question for you to answer. Which lawyer would advise him to continue? But just the game plans for you as well, if you were to speak to both sides.
Yeah, I mean, I can't help but marvel at the irony that this matter has, sort of created, because ultimately you have a constitutional court lambasting the Supreme Court of Appeal for not dealing adequately with the consequences of an order that the Constitutional Court gave that didn't have, an objective arbiter to really determine what the figure should be. And I think that's where this matter ultimately will end, Naledi. It doesn't matter how long it takes. Even when it comes back to the Constitutional Court, I think the way it will end is if there's an independent arbiter, because as it stands, there's an issue with that arbiter having been the CEO of Vodacom. Whether he acted, beyond what he should have done or not, I think ultimately that's probably where the justice sits, and that's where it should end.
Yeah, I want you to give us I suppose the last thought here. Now we're stepping away from it, and I'll let you go first, Benedict, and maybe if we've got time, we'll bring Prof. Cornelius into it as well, just as the legal minds here. It was the swan song for Justice Madlanga before he goes into prepping for the Madlanga Commission. Did he leave us on a good note and in the Concord, Benedict?
I think so. I think this establishes a very high bar for judicial reasoning. And I welcome it, because I think it's front on that when judges don't apply their minds properly, it actually is an affront to the Constitution. And I think we'll start seeing, different sort of JSE processes And I think we'd get a strengthening of, the bench from this decision. So I think he's left us on a good note.
All right. But Prof, your thoughts on Malanga's swan song?
Yeah, I do agree. I think actually this is a profound judgment that will resonate, not necessarily for the Vodacom versus Makate matter, but actually for courts performing their duties going forward. And I can see that this case will be cited very often going forward as, reminding courts on what they should be doing when they exercise their duty. So I think it's actually a very fitting final judgment to give in that sense.
Stunning. Gentlemen, it's been an absolute pleasure speaking to you. Thank you so much for your time. Really a pleasure. Benedict Phiri, legal expert. Mr. Toby Shabshak. Now I need to ask you, not Stuff magazine, Toby?
Just Stuff.
Just Stuff. Okay, editor of Stuff. And Prof. Steve Cornelius, director for the Center for Intellectual Property Law at the University of Pretoria. We've got your headlines at the top of the hour. Stay with us.